All right. Good morning, everyone. Thank you for spending some time with us here at the end of May to go through the recent changes in employment law. For those of you who I haven't met, my name is Julie Reddig, and I am an employment labor attorney here at Lurch Hurley and Brewer. And I am pleased to have my colleague Jessica Summers with me today. Jessica is also in our employment and labor group, and she is going to be covering the multitude of changes in Virginia employment labor law that we have this year. And in addition to that, we're going to talk about just a few changes that we have in Maryland. And then I'm going to talk a bit after we cover the Virginia aspect. I'm going to cover a number of things that we've seen happening at the EEOC, and particularly with the DEI or anti-DEI efforts for government contractors. And then just a few additional things if we have time at the end. So feel free, as always, to use the chat function to ask any questions that you have. And we will try to cover those section by section and also leave some time at the end. And with that, I will kick things off with a brief update on changes that we saw from the Maryland General Assembly this year. So, as I mentioned, just a brief update on the few Maryland law changes that we have. Perhaps the most significant employment law to come from the General Assembly this year is the new ban on what is referred to as an employer's captive audience meeting. And what is that? A captive audience meeting is when an employer mandates workers attend a meeting in which the content is nothing to do with the employee's job, but instead provides management with an opportunity to give their opinion on various matters pertaining to religion or politics. And politics includes union membership. So the law specifically defines the content of these meetings that are banned, and that definition is quite broad. So as you can see from the slide, they've defined religious matters as matters relating to religious belief, affiliation, and practice, or the decision to join or support a religious organization or association. And they've defined political matters as matters relating to elections for political office, political parties, proposals to change legislation, regulations, or public policy, any decision to support a political party or a potential civic, community, fraternal, or labor organization. And really, that last one is the key to what's being the motivation for this ban. These meetings are very useful to management when they are in the midst of a union organizing campaign, because it provides the employer with an opportunity to convey its anti-union message to, as it's referred to, a captive audience, right? So now in Maryland, effective October 1st, employers are prohibited from mandating these meetings, meaning that they cannot discipline or threaten to discipline an employee who declines to attend, participate, or listen in the employer's communication. There's also protection against refusing to hire an applicant who will not participate in such a meeting. The law does not prohibit these meetings if attendance is voluntary. So that will be the path forward for employers seeking to convey messages on these matters. In addition, the law is very clear. This does not address meetings that the employer is having for purposes of communicating compliance with the law, safety meetings, those sorts of things. Also, there is exemption for religious, political, and educational institutions. So if you are one of those, you'll want to make sure that you check to see if your organization is exempt. There are penalties for violations, and they are up to $10,000 for your first violation, and then go up to $25,000 for subsequent violations. And the Commission of Labor and Industry, which is the agency that would be adjudicating those complaints, can also order an employee be reinstated if they were fired for not attending the meeting, back pay and compensatory damages, as well as attorney's fees and costs associated with their claim. Also important to know, there is a notice requirement. So effective October 1st, employers are required to post a notice of these rights in the workplace and provide this information to new employees upon hire. And the Labor Department is set to provide sample notices and posters with this content. So moving forward, you want to make sure that you are amending policies and your onboarding materials to include this required notice. Monitor the Department of Labor's website and our website to make sure that you have that as soon as they are, the sample forms are issued. And then, of course, make sure you train managers and supervisors that they cannot have mandatory meetings if the content is on these topics: religious, political, anti-union matters. Maryland now is one of 12 states that have these captive audience bans, and they are in those states that you typically will expect to be very pro-employee. In many of the states in New England, New York, New Jersey, as well as those in the Midwest, Minnesota, and Illinois, and then the West Coast states. In 4 of these states, groups have sued to challenge these laws. So we will see if litigation occurs with the new Maryland law and keep you posted on that. The other thing to keep in mind for Maryland employers is that the Montgomery County, Maryland minimum wage law is set to be increased on July 1st. So Montgomery County law mandates an increase in minimum wages to reflect the region's inflation rate, which they determined for 2025 was a 2% increase. And so, as you can see on the slide, Montgomery County employers have to increase their minimum wage that they're providing to employees for hours worked beginning July 1st, based on their size or employee count, $18 per hour for the largest employers. And then finally, just a quick note that Maryland did amend its earned wage access law that it passed last year. That law classified earned wage access as a loan subject to the state's consumer loan law and set maximum fee limits for employees who are seeking expedited delivery of earned wage access. The law that they passed last year allowed these providers to accept tips from the employees that are requesting the early payment of wages. And this year, the General Assembly decided to eliminate that ability for these providers to accept tips. And in addition, it implemented some anti-discrimination policies that prohibit these providers from making any kind of discriminatory decisions on the basis of a protected class to any individual seeking earned wage access. And with that very brief Maryland update, I'll turn it over to Jessie to cover the Virginia laws.
So as Julie alluded to, Virginia has had a slew of new laws, in part because this is the first time that the Democrats have held both the state house and both chambers in about 5 years. So there has been a lot of bills percolating over the last number of years that have finally come to fruition. This is an opportune time for us to be doing this presentation because the governor's deadline on a number of these bills to make a decision on whether to veto or to sign the bill passed on the 23rd. So right now what we're looking at is the up-to-date look at what is coming out of the most recent Virginia legislative session. So here on this first slide, I just provided a bit of a timeline on what we're looking at as far as the effective dates to be mindful of all these different laws. We're going to go through chronologically. So for those of you who are creating a checklist of things you need to address, we'll be covering the sort of new ones that are going to go into effect in the next month or so first, and then moving on to the ones that are more a little further out on the horizon. Next slide, please. So the first big change that is coming very soon is Virginia's continued expansion of non-compete prohibitions. So taking back a little on the history here, Virginia's original law restricting the use of non-competes went into effect back in July of 2020. That law, consistent with sort of trends around the country at that time, prohibited using non-competes with what the legislature determined to be low-wage workers. And how the legislature defined low-wage workers was employees whose average weekly earnings were less than the average weekly wage in Virginia, and that's determined annually and published annually. So those folks who are under the $30,000 range over the last number of years have been falling under the definition of low-wage worker and can't be subject to a non-compete. Last year, effective July 1, the law was expanded to prohibit non-competes for anyone who's classified as non-exempt under the FLSA. So that would be anyone who's hourly, anyone who is not a salaried exempt, meaning both the salary and the duties test under the FLSA from overtime, regardless of how much you're paying them. So you could have some folks who are earning very high hourly rates or a high salary, but doesn't meet the duties test. Under the new Virginia law, those individuals could not be subjected to a non-compete. Next slide, please. So there were two new bills that passed this session that are going to further add to that non-compete limitations. And the first is a little bit broader as far as the applicability. The first is that as of July 1, 2026, any agreement that is signed or entered into, and that's going to include an amendment or reissuance of a pre-existing non-compete, is not going to be enforceable to the extent that the employer terminates the employee without cause and does not provide any type of severance in connection with that termination. So it's going to be an interesting nuance here in that you're not necessarily going to know when you're having someone who is an exempt employee that meets the pre-existing requirements for someone to have a non-compete under Virginia law. You're not necessarily going to know when they're entering into that agreement, what the circumstances are going to be of their separation, whether that non-compete is going to be effective when they leave when they're separated, X number of years or X number of months in the future. So really what this is going to do is for those folks who have non-competes that were signed after July 1 of 2026, it's going to force employers to think a little bit more strategically about the separation. So, of course, if someone is terminated for cause, the non-compete can still be enforced. If someone leaves voluntarily, the non-competes can still be enforced. This is really the idea and sort of the policy behind this is preventing employers from binding someone to a non-compete, limiting their options when the employer decides to end the relationship without any justifiable reason or just for their own business reasons without any reason based on what the employee has done, and doesn't offer employees that garden leave concept cushion of some form of severance while they wait out that restricted period. So it's going to be, for those employers who are looking to still enforce non-competes, it's going to be a matter of thinking strategically about the separations and about how you structure severance packages. Also passed, that's going into effect July 1, is a little bit more specific to the individual industries. New non-competes are going to be prohibited with anyone who's considered a healthcare professional. And I've got that definition in the slide, but it's really anyone who is licensed or registered with the state, the Board of Medicine, Board of Nursing, optometry, social work, psychology, except in limited circumstances surrounding the sale of business. So doctors, therapists, for the most part, are not going to be able to enter into new non-competes after July 1, 2026, unless it's a matter of, for example, someone's purchasing the practice and they don't want the doctor who they're purchasing the practice from to go next door. Those types of restrictions are still going to be enforceable and applicable, but you're going to need to make sure that they fit within the scope of that exception in the law. So the one additional expansion on the non-compete law important to recognize is that this is enforced through private cause of action and civil penalties. And the way that Virginia is structured is a little unique compared to some other jurisdictions. Virginia's penalties trigger when someone is asked to sign a prohibited non-compete. So that applies to the restrictions that are now coming into play for the healthcare professionals, as well as the pre-existing restrictions on having low-wage workers and non-exempt workers sign these restrictions. In many jurisdictions, it's once the employer actually tries to enforce the agreement that there's potential penalties, attorney's fees, et cetera. In Virginia, it is when you ask someone to sign an agreement that is prohibited by law. So just be very cautious of making sure that the agreements that maybe we've been using for years and years, making sure that HR and anyone who's administering new onboarding paperwork knows about these restrictions, being cautious about not having folks to sign it. And then finally, there is a posting requirement. We haven't seen the updated notices come out yet, but there is a posting requirement of providing employees with notice on the non-compete law. Next slide, please. So the next big change that is also coming on July 1 of this year is a pay history and a salary history and pay transparency law. And this is a trend that we're seeing in those jurisdictions, like Julie mentioned, sort of the Mid-Atlantic, New England area that tend to be a little more employee friendly. And just the policy background behind it is the idea that individuals' salaries at another job, people may not advocate for themselves and move themselves up the salary rung, and that tends to disparately impact certain groups who are not as likely to be in higher level salaries when they're moving into another position. So Virginia's law prohibits employers from actively seeking wage or salary history from a prospective employee. If the employee shares that information and says, you know, hey, I was earning XYZ at my last job as part of the negotiation, that can be considered, but it can't be asked for. Similarly, employers should not be relying on, you know, salary history or any type of salary or wage information in considering whether to hire someone, in determining someone's wages, or, you know, thinking someone has too high a compensation level that they're not going to bring them in to interview or hire because of the salary ask that they might be making. So that is from the sort of forward-looking perspective of, you know, as people come in the door, what we can ask them. From the public-facing perspective, there's also going to be an obligation in Virginia to disclose on both public and internal posting every job the expected wage, salary, or wage range, and to do that in good faith. So that is going to be really important for anyone who's posting positions in Virginia as of July 1, 2026. It's interesting the way that the legislature has structured the enforcement here. This is enforceable both through civil penalties administered by the Labor Department and a private cause of action. And the way that the private cause of action works with respect to job posting is that if there's a claim for failing to disclose the wage range or failing to set that wage range in good faith, the employer has to be given an opportunity for 15 days to get notice and to cure that. So an employer, you know, gets notice, hey, you've got a posting that doesn't have a salary range on it. The employer has 15 days to correct that before they can be subject to civil penalties or to a private cause of action. But once someone provides that notice, anyone else can rely on that notice for that 15-day notice period. So if you have, you know, Jane contacts you and says, hey, you didn't set a salary or wage range in your job posting. 20 days later, we haven't corrected it. Bob can sue based on that private cause of action. He does not have to separately provide his own notice. He can rely on the notice of someone else. So really important to both make sure that the postings are going up correctly when they're going up, and then also be mindful of the fact that if anyone raises concerns about it, you want to look into that very promptly. Next slide, please. So also we saw in the most recent legislative sessions our expansions to the Virginia Human Rights Act. This is the civil rights legislation in Virginia. The VHRA currently prohibits discrimination based on race, color, religion, ethnic national origin, sex, pregnancy, childbirth, related medical conditions, age, marital status, sexual orientation, gender identity, disability, and military status. So this is a catch-all, large, expansive anti-discrimination statute. Interestingly, there was some news around it because it was going to be one of the first pieces of legislation to this effect in the country. On May 19th, the governor actually vetoed a bill that had passed that would have added menopause and perimenopause to the list of protected categories. The governor had originally tried to send it back to the legislature, asking that the legislation be amended so that it was a study on whether that bill was necessary first. Legislature sent it back to the governor as it was originally passed, and so the governor vetoed it, and there's not sufficient votes to override that veto. So we're standing with the current VHRA definition, but that of prohibited categories, but that is still a broad definition. Under the new law, there's been an expansion in that the definition of employer for all claims under VHRA is employers with 5 or more employees. So being mindful of the fact that this is a lower threshold than, for example, Title VII or the ADA. This cleans up some of the issues for those of you who are in Virginia. You may be aware that for some categories it was 15, for some categories it was 5, for some categories. So it's actually somewhat helpful in that it provides a clarity of the definition, but it does mean that if you're a smaller employer in Virginia, be aware that now there is this expansion that is potentially bringing the VHRA down to you. It also expands the amount of time that someone has to file a charge of discrimination with the Virginia Office of Attorney General from 300 days to 2 years. So essentially doubles that time that someone has to pursue a claim after an alleged discriminatory action. Next slide, please. So also on the July 1st, 2026 train, we have an expansion of Virginia's wage payment and misclassification penalties. These are the penalties that apply for failing to pay wages in Virginia. So if someone is misclassified, does not get their overtime, or if someone is not paid for time worked, these are the penalties that come into play. It expands the definition of employer, and most importantly, for those of you in Virginia, this is potentially triggering the way that this definition has been amended, likely going to be a subject of litigation, but is potentially triggering individual manager liability for non-payment of wages if there is a high-level manager who is responsible for payment of wages. That is consistent with some of the other jurisdictions in this area that do have the potential for individual liability for non-payment of wages. It also expands the definition of wages to make it clear that it includes all forms of wages, not just hourly wages, salary. It also includes commissions, tips, bonuses, and damages. It also lengthens that statute of limitations to 3 years, and requires that employers maintain pay stubs for 3 years, and finally allows for collective action. So it really doesn't change anything as far as the compliance side other than retaining those pay stubs for 2 years, but it emphasizes the importance of making sure that classifications are correct and that wage payments are being made correctly, because it increases the potential liability and potential costs of a misstep here. Next slide, please. So this one is a little bit easier. Virginia has also implemented protections for voluntary emergency responders. I've laid out the information on the slide, but the big thing is if you have folks who are voluntary emergency responders that are actively called to a state of emergency or an emergency alarm, generally there are now protections for any type of retaliation against them. There are certain positions where someone's essential based on the statute or contract where you don't have to provide them with that time away. But generally, for someone who is a voluntary emergency responder, this is requiring and protecting their ability to take that time to satisfy their duties. Next slide, please. So moving to, so everything I've talked about up to this point are July 1, 2026 pieces of legislation that are going to go into effect. So something that those things should be on your immediate radar. Looking a little bit further ahead, Virginia did join the cohort of states that are pushing towards a $15 minimum wage. Virginia's current minimum wage is $12.77. Consistent with this push, that minimum wage will increase again in January 1st of next year. And then January 1, 2028, Virginia will join the states that have a $15 minimum wage. Important to note, there will also be CPI adjustments after that. So Virginia's minimum wage, unlike some of the other jurisdictions that just have a flat ceiling at $15, Virginia's minimum wage is likely going to increase slowly over $15 as those annual CPI adjustments occur. So just being mindful if you have folks who are on the cusp of minimum wage that you're going to want to make sure that you are paying them correctly and that you're looking ahead strategically and budgeting for those increases. Next slide, please. So the one that's been making the news a lot is Virginia has become the first southern state to both implement mandatory paid sick leave and paid family leave. So what does that mean? Focusing first on the paid sick leave. For those of you who have employees in Maryland and DC, this is going to be familiar to you because it is fairly consistent with those laws in Maryland and DC. Requires employers to provide all employees with 1 hour paid sick leave for every 30 hours they work, up to 40 hours per year. The law will have rollover requirements. So if someone's accruing through the year, they get to roll over unused leave to the next year, though there can be caps on how much leave they can use per year. Um, the effective dates are going to phase in, so this isn't an immediate thing for most employers to worry about. The soonest is going to be those with 50 or more employees. This requirement to provide this paid sick leave is going to go into effect July of next year, so 2027. Employers with 25 or more employees get included January 1st of 2028, and then everybody, one or more employees expands out on January 1st of 2029. So there is, particularly for small businesses, going to be time to plan for this. We're also expecting that there is going to be some regulations, guidance coming out. The use of paid sick leave is fairly consistent with the uses we see in other jurisdictions. It's for the employee's physical or mental illness, need to seek care for themselves or a family member related to those mental or physical illnesses, or to seek the safe element of the leave, to seek services or relocation or pursue court cases if there's an issue of domestic abuse, sexual assault, or stalking. I will note that unlike some of our other local jurisdictions, the Virginia paid sick leave does not include in its paid sick leave purposes parental leave. So that is a little bit different from some of the other jurisdictions we're seeing around. But we're expecting that there's going to be more guidances, that there's going to be more notice, but being aware that this is on the horizon. And particularly for those of you who are rolling out new policies, we've been seeing some employers getting questions from employees because they're seeing this. This is making headlines of when do I start getting my paid sick and safe leave? Just being aware that this is on the horizon, but not immediate, and being ready to communicate that to employees. Next slide, please. So also on the horizon, going chronologically before we hop to the paid family leave, is overtime for domestic workers. This is going to extend Virginia's overtime pay laws, which, like most other jurisdictions, require 1.5 times the regular hourly rate for any hours worked over 40 in a work week to domestic workers, which will include housekeepers and au pairs who are previously excluded. Interestingly, the way this legislation bounced back and forth between the governor and the legislature, the law is only going to become effective on July 1, 2028, if it's reenacted next year. So next session of the General Assembly, that's early 2027. If they reenact this law, then the law will go into effect on July 1, 2028. If they don't, it will not go into effect. But for those who are in the space of having domestic workers, who have their own domestic workers, being aware that this is potentially on the horizon, but not guaranteed. Next slide. And so the final big change that we're looking at, and this is a 2028 horizon, is that Virginia is joining those states that has paid family and medical leave insurance program. So that for those of my clients that are not familiar with this, the way I've been describing it, it's really a publicly administered short-term disability system. And for those of you who have employees in DC, you are familiar with this. DC already has its paid family leave insurance program up on its feet. Maryland is still working on it, has been bumped and bumped and bumped a number of times. So presumably we're going to see Maryland's go into effect before Virginia's, but it remains to be seen at this point. The program in Virginia is going to be administered by the Virginia Department of Health, and there are going to be significant implementing regulations that are going to be forthcoming. The way that the program works is that it is funded through payroll contributions from the employer and the employee. The exception is that employers with 10 or fewer employees are not going to have to contribute to the fund, but there still will be payroll deductions from those employees. Those contributions and the building of the fund that is going to pay out these benefits is going to start April 1 of 2028. The amounts that are going to, the employer and the employee will be paying into the fund are going to be set by the VEC. and consistent with the statute. So stay tuned for that as we get closer, as far as the obligations and the implementation. And as we generally see for those who are using an ADP paychecks, the standard payroll companies usually catch up and are prepared to help implement those types of withholdings once that comes into play. For those who are doing their own manual paychecks, maybe a little bit more complex, and take some additional steps. And then employees can actually start applying for the benefits December 1 of 2028, with the idea that so essentially at that point they can start taking those benefits and getting those benefits. Next slide, please. And so what those benefits are is that they are wage replacements for up to 12 weeks of leave for a number of purposes. And they are generally consistent with the FMLA purposes, even though this is going to apply to employees who are in jobs that they may not be FMLA eligible because of the size of the employer. But the purposes are going to be caring for a child, family member sick, the employee is sick and or has a serious health condition that makes them unable to perform their own position. There is a covered service member who's the employee's next of kin or family member that they're caring for. There's exigencies related to the fact that a family member is in the armed forces or has been called to active duty, or those safe purposes I talked about in the context of sick and safe leave, seeking safety services for the employer or family member if there's domestic violence, sexual assault, or stalking. So an individual who needs to take time away from work is going to be able to apply through the state to have wage replacement benefits for up to 12 weeks of time off for that. There are going to be caps on the benefits that get paid out. So someone who is a very high or higher wage worker is probably going to be hitting that ceiling, which is going to be established by VAC. So they're not going to be seeing a complete wage replacement or close to complete wage replacement. And there are provisions to allow the employee to coordinate benefits. So these leave benefits are going to run concurrently with any FMLA leave that the employee is entitled to. And then also the employer can dictate coordination with short-term disability and other leave policies. So if you already have a parental leave program or you have a short-term disability offering, this can be coordinated and synced with that. So it is not going to be a situation where the employee is necessarily going to be stacking this 12 weeks on top of the short-term disability, on top of a parental leave, or on top of some type of unpaid leave. It's going to be a matter of explaining to employees and coordinating exactly how the different types of leaves and the different types of programs that the employer offers works. But we've got time for that to come, looking at, again, December 1st of 2028, but do have that on your mind and on your planning if you have Virginia employees, and be prepared to have those discussions, because again, this is making news in the area, and we are seeing employees come with questions about, when am I going to be able to take this? So not quite ready to be implemented yet. And if Maryland is any suggestion, the VEC has a fairly heavy lift ahead of it in setting up and implementing this. So, April of 2028 is the earliest that we're going to see contributions. Whether they're going to have everything set up properly by then, or whether they're going to need to have amendments to extend that timeline like Maryland has had, remains to be seen. But certainly a lot to stay abreast with in Virginia and to be prepared. And I know we ran through things extremely fast, to get everything in today, but please don't hesitate to reach out if you have folks in Virginia and need some help complying with any of these new requirements.
Thanks, Jessie. There's a couple questions for you in the chat. I'll just go through them so everyone has an opportunity to hear. So first question is on the salary, the wage transparency law in Virginia. Does the mandatory disclosures that have to be made, is it just base salary, or does overtime eligibility and bonus eligibility have to be included as well?
So it is the wage. I mean, typically most employers are posting the wage range. So it's not, base salary. I think for recruiting purposes, bottom line is it's base compensation and what someone can expect to earn. So if there are contingent factors such as discretionary bonuses, things like that, you don't have to include them. But from the perspective of the employer, if you're trying to recruit someone, most of our clients in jurisdictions that are already requiring these wage disclosures are wanting to have their compensation levels look as generous as possible. So they are including reference to, base salary range expected between X and Y, but also eligible for overtime, eligible for bonuses. But what they're looking at right now, or as far as the law is concerned, is a good faith representation of either the expected hourly rate or the expected base salary.
And on that same law, would you advise an employer to ask a candidate about salary requirements during the interview process?
I think that you're playing with fire a little bit there because during the interview process itself, I would potentially wait until you are at a later stage, just because we don't want a situation where the employer can be accused of fishing for someone's hours expectation, have someone come out of the interview and say, well, they asked me what my expectations were, but I interpreted that the way they phrased it as seeking my wage history or my salary history. So I think you want to be, if you are going to ask that question, I think you want to be really careful the way you do it. And you don't want to be making decisions based on what the employee's wage or salary expectations are. So I think that the conversation about what your salary expectation is to make sure that you're offering a package that's going to um, appeal to the individual who you've selected are better had at the later stages of the process. So after you've conducted that, initial interview, not because the law strictly says you cannot ask someone what their expectations are, um, but because of the way it's phrased, the way that it's phrased, and depending on who's phrasing it, we don't want employees to turn around and say that this was fishing for, what the expectations are is based on what you're currently making, or that you're seeking a sort of backdoor.
And for the person that asked for a repeat on the information on the wage disclosure, pay transparency law, I put that slide back up. Who would be covered under this law, Jessie? Would there be coverage if an employer, let's say, has an office in Virginia, but the worker could be in any location because they're working remotely?
Yeah, so that's a great question, and I'll go back and double check to make sure that the legislature hasn't opined on that, but um in the legislative history and the discussions there, this is a big issue that employers have been seeing around the country as far as whether or not the job could be based in Virginia, particularly if you're posting for a remote position or a fully remote position where someone's not going to be reporting to anywhere but could be working from their home in Virginia. Colorado actually was the very first jurisdiction that implemented something like this. And so that's why you actually see in a lot of job postings for remote positions, you see these very specific pay requirements. And that started a few years ago because when Colorado passed their bill, they specifically included language in there saying if this job could be based in Colorado, if it's remote, you have to include these postings. And by the way, multiple jurisdictions have now started passing bills saying you can't include a caveat in your posting that, this is a remote position, but it can't be performed from California, Colorado, and the list of the states that have the pay disclosure requirements to avoid that. So I would say for local folks, if you are hiring someone who's going to be based in Virginia, who could be based in Virginia because it's an entirely remote position, or it's a very strongly hybrid preference position. So, coming into DC once a month or once a week, and they may be working in Virginia for the other, 4 days a week, 80% of their time. I think you want to be really careful, and over compliance with all of these potential all of these wage disclosure requirements is the best way to go, especially because of the potential for a private cause of action and civil penalties. I mean, granted, the nice thing with Virginia's law is it does give you a chance to correct it. So if you have someone reach out, and I think part of it was the concept on there are, with the other states that have these laws, there have been individuals and groups that essentially go on fishing expeditions and find postings, and sue over postings, even though, the individual really had no intention of, applying for that job, but they are based in Colorado and have a tech background. So they're suing someone who is hiring someone fully remote in Colorado. At least the nice thing with Virginia's law is that before someone can sue you, they have to give you notice and give you the opportunity to address it. So again, if you have a situation, even if you are not based in Virginia, but someone reaches out and says, I think you're violating the Virginia wage law because you're posting a remote position or a hybrid position, take that seriously and let's take a look at it together. Because generally all of these states want to include as many employers as possible and as many posters as possible.
And this law is effective July 1st, right?
That is correct.
And a question on the sick leave, the new sick leave law. If an employer has PTO and includes, sick and vacation all in a PTO policy, do they need to make any adjustments to comply with this law?
It depends on what the PTO policy currently looks like. So that employers can satisfy the requirements, just like in Maryland and DC. You can satisfy the requirements of the paid sick leave through offering a more generous program of PTO. So you don't have to just do paid sick leave. You don't have to stack paid sick leave on top of PTO, as long as the PTO you're providing is at least as generous as the leave that's otherwise being offered. So the big thing that we see as far as PTO policies when we've seen these come in Maryland and DC as examples, and we have clients who have pre-existing PTO policies that they want to keep. The big things that we're looking at are the use restrictions compatible with what the state requires. Often the PTO policies are going to require a carve out because most PTO policies say you have to request this leave at least 1 month in advance so we can plan for it. You can't do that when it comes to paid sick and safe leave purposes. So usually the PTO policies we're having to draft carve out saying, except if it's a protected paid sick and safe leave reason. Similarly, things like rollover, the PTO policies have to comply with the rollover requirements for the states as far as the minimum amount of leave that needs to be rolled over. So we would need to look at and just make sure that the accrual, the rollover, and the use and compliance elements are consistent and at least as generous as the paid sick leave. Make any changes necessary to the PTO policy, but PTO itself, in theory, can satisfy the requirements. It's just don't assume if you're an employer that you are already satisfying the requirements just because you offer PTO.
Great. Well, thanks so much. If others have questions, feel free to put them in the chat, and we'll see if we have time to address them at the end. And now I'm going to switch gears to some federal law. Moving forward here on the slides. So some new interpretations, if you will, of Title VII and general discrimination principles. I'm going to start first with a case. I think this might be the only case we're covering today, but important nonetheless. And this is a case out of the Fourth Circuit Court of Appeals, which is the federal circuit court that has jurisdiction over Maryland, Virginia, West Virginia, North and South Carolina. So in this case, which is Thomas versus EO Tech, the Fourth Circuit addressed a challenge by a former employee as to their former employer's attempt to shorten the period of time that the employee has to file a lawsuit after experiencing discrimination. So this employer had an onboarding process that incorporated a pre-employment limitations agreement, and that included a clause that lawsuits had to be filed within 180 days of the alleged discriminatory action. So after this employee was terminated, they filed a discrimination charge with both the EEOC and the Maryland Commission on Civil Rights. And if anyone has been through that process, you'll know if the EEOC does not find sufficient support for or evidence indicating that discrimination has occurred or chooses not to file suit on the employee's behalf directly, there is a right to sue notice that is issued. And so that happened in this case. That right to sue notice says that the employee has a period of 90 days upon receipt of the right to sue notice to file suit. In this case, that right to sue notice time frame, that 90-day period, fell outside the 180-day period from the alleged discriminatory act that formed the basis of the discrimination charge. And that was the limitation that the employer had imposed through that contractual requirement. So they moved to dismiss the lawsuit when the employee filed it. While they were successful at the trial court level in Maryland, the Fourth Circuit said, no, employers don't have the right to adjust filing deadlines under Title VII. They can't be shortened by private agreement. This law provides employees with the right to file suit, under that statutory scheme, which gives 90 days after the EEOC issues the right to sue, and that can't be shortened by any type of agreement. So interestingly, the court also noted that that might not be the case under Maryland's anti-discrimination law. So I think it remains an open question whether employers could potentially shorten the limitations period for a discrimination claim under Maryland law, but certainly clear in the Fourth Circuit that employers cannot do that under federal law. So if you have such an agreement in place, make sure that you revise that to make clear that any limitations period is the period that is provided under federal law, to make sure that you don't run afoul of this case going forward. Next, I'm going to talk a bit about the EEOC and all of the new interpretations that the EEOC is doing with regard to Title VII and the actions that it is taking, in some instances, changing things that have been in place for decades. So first up in that regard is the EEO-1. We might be seeing the end of the EEO-1 report quite soon. So the EEOC has proposed to eliminate that report, as well as the EEO-2 and 3, 4, and 5, which are the data collection reports for unions, state and local governmental entities, and public schools. Currently, the White House is reviewing the proposed rule. Its Office of Information and Regulatory Affairs. That office makes sure that the proposed rules are consistent with presidential priorities and legal requirements, and that generally takes about 90 days. So if that office approves the EEO's proposal, then the rule will be published in the Federal Register, and it'll go through that regulatory process that we have in place. So unclear whether or not this is going to be, when this is going to be effective. We anticipate that office will approve it, and it will be published at some point in the coming months in the Federal Register. However, we are anticipating that reports for 2025 information that are filed in 2026 will be required. The question is whether or not reports will need to be filed next year for 2026 information. There is certainly, as with any broad sweeping change like this, an anticipation that there will be litigation. And while a final rule could be certainly overturned by Congress, particularly depending on midterm election results, we think that it is possible that President Trump could veto that, and it could be very likely there wouldn't be 2/3 majority to override the veto. So we think that it's likely that we might see the end of the EEO-1 at some point in the next year or so. So if that happens, employers will want to consider their current data collection processes, those processes that you have in place for completing the EEO-1, given that this administration believes that the tracking of race and sex data is, in some instances, indicative of what they refer to as illegal DEI. And specifically the practice of setting goals and monitoring that for diversity in the workplace. You will want to take a hard look at whether or not you need to continue doing that under going forward, or whether that proves to be too much of a risk. So keep an eye on this development as we move forward. Next, I want to talk about what the EEOC is touting as their successes and focus areas in the first 15 months of the Trump administration, because again, they are using some different interpretations of the law, and I think it's important that you as HR professionals are aware of those different interpretations and are making sure that your frontline managers in particular are issue spotting potential violations so that you can make sure that you are in compliance with applicable law, or if you choose to challenge it, that you're doing it with knowledge of potential litigation risk coming from it. So the first focus that the administration or the EEOC has touted is that they are protecting religious freedom. And they explain that their efforts have been exhaustive to restore what they say is even-handed enforcement of all of these employment and civil rights laws. So that term even-handed enforcement is so different, right, than the efforts that we saw in previous administrations. And again, we want to make sure that you're aware of how they are interpreting that. So on the topic of protecting religious freedom, since January of 2025, the EEOC has filed 16 religious discrimination suits and recovered over 63 million on behalf of religious workers via various efforts, whether they be public litigation in the courts or private pre-litigation voluntary settlements referred to as conciliations in the EEOC process. And so some examples of those so that you're aware of the things that the EEOC is focused on. In March of 2026, the EEOC settled a $15 million public conciliation on behalf of dozens of workers who were denied religious accommodations from COVID vaccine mandates. The EEOC has filed 4 lawsuits alleging religious discrimination and accommodation claims related to COVID vaccine mandates. I am, very hopeful that we never have to deal with the concept of a vaccine mandate in the workplace going forward. But if we do, unfortunately, this litigation will be important to keep in mind as you move forward with any accommodation efforts associated with that mandate. The other lawsuits that the EEOC has filed or settled recently in this area against private employers involve requests for accommodation for Sabbath observances and religious meetings. So a little bit broader, perhaps, than what you have thought is a religious observance that needs to be accommodated. So, for example, an overnight desk clerk at a hotel requested not to work the Saturday overnight shift because it interfered with his ability to attend and lead services at his church the following Sunday. And so that was a lawsuit that the EEOC took on. A case involving a truck driver who filled in once on a Sunday because they needed help and then began to be scheduled regularly on 4 Sunday morning shifts, objected to that and requested religious accommodation. And when that wasn't successful, the EEOC filed suit on that employee's behalf. And then in another case, a Christian employee alleged that they were unable to take off to attend Sunday services and meetings that were required of this individual as a church leader. And that case was settled at conciliation for over $100,000. So really make sure that your managers are briefed on, when employee makes a request to not take a shift or change a regular work schedule, or even, refuses to fill in on an interim basis. We're heading into vacation season. It could be that you're looking for folks to work on certain days. Maybe it's an evening shift. Maybe it's on a Sabbath observance or a holiday. Make sure that they're aware to rope in HR if the employee mentions anything about a religious observance or religious service, so that you can avoid running into an issue here with the EEOC. The other area of focus for the EEOC is protecting American workers from what they're referring to as anti-American bias and a preference for foreign workers. So back in November, the EEOC released a new and updated educational materials on national origin discrimination under Title VII and made clear that that included anti-American national origin discrimination. Chair Lucas believes that there is a widespread problem in many industries, employers having policies and practices that prefer illegal aliens, migrant workers, or non-immigrant guest workers over American workers. And they are using their litigation to demonstrate this to Americans. So earlier this month, the EEOC filed suit for national origin discrimination and retaliation against a construction services company. According to the EEOC's lawsuit, 2 employees were subjected to anti-American slurs by their Mexican coworkers. An employee had their tools taken away from them, impeding that employee's ability to work. And that employee's directives were ignored by other employees, and those employees derided him, made fun of him because he was not able to speak fluent Spanish. The employee complained to their supervisor. The supervisor didn't address this, and that resulted in additional harassment and complaints. So then the employee went above their supervisor's head and made a complaint to the next level supervisor, and that resulted, according to the employee, in their being fired. And so the employee has, filed with the EEOC, and the EEOC has decided to take on this employee's case and filed suit against their employer. So important that you are making sure that managers have a keen eye to this, anti-American bias, particularly, could be creation of a hostile work environment. If you have an employee who, isn't able to speak Spanish, let's say, for example, is here, or, isn't of the same culture as many other workers in the workforce or on a project or at a job site or something along those lines, that managers are stepping in and addressing that the same way they would if it was the other way around. Third priority for the EEOC is defending women's sex-based rights at work. In January, you might have seen, I think we covered in our last session, that the EEOC voted to rescind the 2024 enforcement guidance on harassment in the workplace, and specifically explained that that was because the guidance took a position that harassing conduct under Title VII includes denial of access to a bathroom or other sex-segregated facility consistent with an individual's gender identity, and that harassing conduct includes repeated and intentional use of name or pronouns inconsistent with an individual's known gender identity. In February, the EEOC issued a federal sector appellate decision that recognized the ability of federal agencies to designate intimate spaces in federal workplaces by sex, and held that Title VII permits an agency employer to maintain single-sex bathrooms and similar intimate spaces, and permits a federal agency employer to exclude employees, including trans-identifying employees, from opposite-sex facilities. So it is, the EEOC is signaling how it will treat these types of cases should it come before it. And presumably the same would be true if it was a private employer, given that Title VII applies equally to the private sector. Also important to note that the EEOC has a former employee, that has filed suit against it, challenging the rollback of transgender bias, claiming violation of Title VII. This employee says that the EEOC itself discriminated against him and retaliated against him by ordering employees to stop processing transgender bias discrimination, and eliminating its employee resource group called EEOC Pride, that was supporting LGBTQ plus employees and their allies, and rescinding the internal non-discrimination and inclusion policy regarding gender identity and sexual orientation at the agency. So this employee said that they experienced tremendous stress because of this and resigned their employment. That case is pending in federal court in California. So we will see if it has any impact on the EEOC's positions moving forward. And then the final area that the EEOC and many other agencies, but here we'll talk about the EEOC, are focused on is what they're calling attacking illegal DEI related to race and sex discrimination. As we've been talking with you about for the entire 15 months of the Trump administration, the administration has not let up on its anti-DEI initiative. And the EEOC's efforts in this regard are featured prominently in a recent case. You might have seen that the EEOC has filed suit against the New York Times, claiming employment bias against white men. The most recent this most recent suit has received a fair amount of attention in the regular press. Here, the employee of the Times was applying for a editor position. The plaintiff is a white male with extensive experience in real estate journalism, and was applying for a vacant editor role in early 2025. According to the EEOC's lawsuit, every candidate who advanced to the final interview process was not a white male. And the selected candidate was an outside hire, a white female with no experience in real estate journalism, despite the Times claiming that this was required for the role. And according to the EEOC, the final interview panel rated this candidate, the one that was selected, less favorably than the other two final candidates. Now, what's particularly interesting is how the EEOC is supporting its claim that there was a violation of Title VII in the selection of this candidate. And that is that they're pointing to the Times' well-documented commitment to enacting race and sex conscious decision-making in the workforce through its diversity, equity, and inclusion policies. Specifically, the Times has a plan that they adopted in 2021 aimed at building a more diverse company. And it published annual reports on diversity and inclusion for the last decade, demonstrating its efforts to make decisions on the basis of race and sex to achieve desired demographic goals. And so the EEOC is using this information to allege that these stated goals and action plans were to increase non-white and female representation in leadership positions. And because a natural consequence, they say, of having these policies would be an intent to decrease the percentage of white leaders in the organization. Now, the Times has denied that race or gender played a role in the hiring decisions, so we will see how this plays out in federal court in New York. But going back to what I said a few slides ago, this is an indication of how the EEOC is using data that employers are collecting for purposes of diversity to potentially indicate that discriminatory decisions are being made for hiring or promotion. In addition, earlier this month, the EEOC intervened in an appellate proceeding of a lawsuit filed by a former professor at Temple who is alleging discrimination in Temple's decision to deny him tenure. And similarly, in support of that, they're pointing to Temple's diversity and faculty hiring preferences that they had published several years ago as evidence of the bias against this professor's attempt to obtain tenure. And then in April, the EEOC obtained a $500,000 settlement in a lawsuit on behalf of an Asian male applicant, which a company rejected as, quote, not diverse and too old. And the lawsuit alleged that the employer instructed its recruiter to identify diverse candidates for this position, discuss goals to identify candidates based on gender and ethnicity, and noted its willingness to dispense with some of the relevant qualifications, including certain experience, depending on whether the candidate had certain protected characteristics. So all of this to demonstrate that really any efforts that you're using on, to increase diversity through specific instructions in your recruiting and hiring processes could be used as evidence of discrimination under Title VII. And then a case that involved internal DEI practices, the EEOC settled a public conciliation with Planned Parenthood of Illinois in March, alleging that Planned Parenthood's DEI practices that included segregating employees by race during mandatory weekly racial affinity caucus meetings, subjecting white employees to harassment in its DEI trainings, and engaging in disparate treatment against white employees regarding terms, conditions, and privileges of employment. So be cognizant of how, if you have ERGs or similar affinity groups in the workplace, make clear that all of those are open, they're voluntary, and they're open to anyone who is interested in participating in them. Any type of segregation or mandating participation in that will certainly run into challenge by the EEOC. So takeaway from this enforcement priorities of what we're seeing from the EEOC, again, train your managers, make sure they understand what a religious accommodation is. Any request for a different type of schedule could potentially, if there isn't a religious accommodation analysis done, could run afoul of Title VII. Make sure that they understand that anti-American bias is equally prohibited, as well as bias on any other protected classifications, and the risk of setting goals for diversity in hiring and promotion decisions. Review your any type of criteria that you're using for selection and whatnot, to make sure that there is no additional emphasis on diversity, and that everyone is treated the same way, and that the qualifications for the role and someone's experience are what are the decision for hiring is based on. And then, of course, make sure that your training content and your affinity group structures aren't going to create an issue for you under Title VII. Okay, so now I just want to turn to a big change that all federal government contractors are having to grapple with moving forward, and that is Executive Order 14398. That was issued by President Trump on March 26th, and that executive order is entitled Addressing DEI Discrimination by Federal Contractors. And so in issuing this executive order, all executive departments and agencies of the federal government are now required to add language to federal contracts that bars racially discriminatory DEI activities. The Trump administration's rationale for this executive order is that racially discriminatory DEI activities impose artificial costs in hiring, promotion, and operations, create excessive workforce turnover, reduce the available labor pool, and generate inefficiencies that are being passed on to the federal government through contractor pricing. So the FAR Council issued a memorandum on April 17th that provided guidance to these agencies on how to issue contracts and implement this executive order. And that memorandum sets forth the new contract clause that must be inserted into all new solicitations and resulting contracts that are valued over $15,000. So this is pretty much all of them, beginning April 24th, 2026. And that's for new contracts. For existing contracts, contracting officers are instructed to make unilateral modifications to the extent possible by July 24th to insert the clause. And the memorandum says that any contractor who refuses that modification may result in the agency determining that the contract no longer meets its needs, and could be terminated for convenience. So we are seeing these be implemented at the present time on new contracts, and anticipating more attempts at implementation in existing contracts in the coming weeks. So what does this clause require? What does it say? This clause says that the contractor will not engage in any racially discriminatory DEI activities, which the order defines as disparate treatment based on race or ethnicity in the recruitment, employment, such as hiring or promotions, contracting, including vendor agreements, program participation, or allocation or deployment of an entity's resources. So very, very broad list of activities that a contractor is not allowed to engage in. The law defines program participation to include membership or participation in or access or admissions to training, mentoring, or leadership development programs, educational opportunities, clubs, associations, or any similar opportunity that is sponsored or established by the contractor or the subcontractor. So for federal contractors and subcontractors, this is now a new compliance obligation. It is in addition to Title VII. It is more narrow in the sense that the definition is focused only on race and ethnicity, not the broader category of protected characteristics under other federal laws or other prior executive orders issued by this administration. But it is much broader in the sense that it doesn't cover just hiring and promotion of employees, but also in how that contractor is allocating resources, right? Is there some kind of diversity program that the company has in place for vendor relationships, for its subcontracting? What about development and training programs? Is there funding that is provided to increase, diversity in leadership? And so there's a leadership development program in place by that contractor. So all of that is potentially classified as racially discriminatory DEI activity, and would be in violation of this executive order. So what are the requirements? The government contractor has to furnish all information by their CO for compliance with this directive. So if there is an information request, which we anticipate will probably be how they move forward with trying to enforce this, there must be compliance with that. In the event of non-compliance, there could be a cancellation of the contract or a suspension, and there could be debarment for any contractor that is engaging in this activity that violates this executive order. In addition, there is a requirement that contractors report any subcontractors' known or reasonably knowable conduct that may violate this clause to that contracting officer, and take appropriate remedial actions as directed by that contracting officer. So this is, a bit of an additional requirement that higher tiers need to be aware of what their subcontractors are doing with regard to these types of, programs, hiring decisions, recruitment, funding, all of that. There's a requirement that the contractor inform their CO of a subcontractor lawsuit that is putting this clause at issue. And there is a statement that says that compliance with this requirement is material to the government's payment decisions. And that is included because it is establishing a factual predicate necessary for proving liability under the False Claims Act. And while it'll certainly be challenged in any litigation that results from this, this will likely be used to influence action by the Department of Justice on an FCA claim, which we are seeing them engage in for anti-DEI activity, or for DEI activities, illegal DEI activities, and potentially also in the courts. There is a flow down requirement. The contractor must include the substance of this clause in subcontracts of any tier, including those for commercial products and services for which delivery is in the U.S. So the new order will be enforced through cancellations or suspensions of contracts, suspension and debarment of contractors and subcontractors, or failure to comply with the clause, and then also that False Claims Act enforcement from the Department of Justice. Now, this new executive order is, of course, like they all tend to be, subject to legal challenge already. There is a case pending in federal district court in Maryland alleging that this violates the First Amendment. But for the time being, compliance is required. So moving forward, you want to make sure that if you're a federal contractor, that you are incorporating that flow down clause in your subcontracts when you are required, that you're reviewing your existing practices and making changes to ensure that you are complying. As a reminder, it's not just an anti-discrimination statute, so it would apply to those mentoring initiatives, diversity programs for suppliers that you have in place, ERGs, scholarships or internship programs that are focused on particular groups, diversity initiatives, resource allocation decisions could include philanthropy, where you're donating, and you want to make sure that you identify any activity that could be characterized as involving disparate treatment on the basis of race or ethnicity. You want to make sure that your compensation and bonus, as well as promotion decisions, are not based on achieving demographic goals or considerations of race or ethnicity in these decisions. And of course, the larger question is how this is going to be applied to your subcontracts that have small or disadvantaged business classifications, including those subcontracting requirements that are required by the SBA. So we will see how that plays out. Of course, if you are making the decision to maintain any program that could potentially, run up against compliance issues under this new executive order, you want to document the business purpose of the program, whether that be improving efficiency, expanding talent pipelines, whatever. That will be a requirement for, having success in challenging compliance under this executive order. You also want to think about how are you going to comply with the obligation to monitor known or reasonably knowable subcontractor violations. That could be through some sort of certification that you're including in your subcontracting process. That certainly at a minimum, you want to have some documentation showing that you made some effort to ensure compliance and gave notice of the law. But you might also want to be monitoring a subcontractor's behavior. If they're touting their program for a diversity initiative that you think might run in afoul of this law, you want to, potentially report that under this executive order. Okay, and as I mentioned, the DOJ is getting into this anti-DEI effort under the False Claims Act, and it was important that the DOJ, or important to note that the DOJ announced that IBM, they reached a settlement with IBM under which IBM is going to pay $17 million to settle a False Claims Act case. And I think this is important for everybody to be aware of because it kind of shows what are the activities, the quote unquote illegal DEI activities that an employer could be engaged in that the administration is going to consider to be, a potential grounds for a False Claims Act lawsuit. So in this instance, according to the DOJ, IBM was engaging in compensation decisions that included race, color, national origin, and sex. Specifically, they had a diversity modifier that tied bonuses for supervisors, managers, department heads to hitting certain demographic targets. They had hiring practices that altered interview criteria based on race or sex. They had diverse sourcing for requirements for transfer and promotion decisions. And they had a requirement for a diverse interview slates for hiring. IBM, according to the DOJ, had demographic goals and were basing employment decisions on consideration of these goals. And then they also had exclusionary programs and trainings. So specific trainings and mentoring and leadership development or educational resources that were provided to certain employees on the basis of that employee's race, color, national origin, or sex. Now, of course, IBM denies all of this, denies that they're engaged in any of this quote unquote illegal DEI, but presumably decided as a business decision that it was cheaper to pay $17 million than lose their federal contracts going forward. Also important to note that the DOJ noted IBM got credit for cooperating with DOJ's investigation and disclosing relevant facts early on based on its own investigation. So we are likely to see more whistleblowers in light of this decision or the settlement at the high dollar figure of the settlement, particularly under this False Claims Act case. And so again, another reason why employers want to really be reviewing their existing programs, practices pertaining to compensation and employment decisions on the basis of race, sex, and national origin. And then in our final few minutes, just a few, I think 2 additional topics I want to make sure that you're aware of outside of the Title VII area, which is ICE has adjusted penalties for errors on the I-9 form. So the errors on I-9 used to be, or still are, I'm sorry, split into 2 types. So there's substantive violations. That's when you have a violation that leads to hiring an unauthorized worker. That type of violation results almost immediately in a monetary fine. But then there are other types of violations, things that are kind of technical mistakes, right? Clerical errors, things that could be easily corrected. And it used to be that those types of violations, if you were, let's say, subject to an audit and that was discovered, that you could had the opportunity to correct those and wouldn't be subject to direct, immediate financial penalties. Well, now ICE has decided that that's not the case. Many of these technical or procedural violations are going to be considered substantive errors and subject to immediate fines. So things like missing an employee's date of birth on the form, a mistake on the employee's name or not completing it, not completed Section 1 fields or attestations, including the employee's signature, failing to enter dates of employment or dates of hire, using a Spanish language form outside of Puerto Rico because that's no longer permitted, and failing to check a box for alternative procedures if you're using that remote verification process. So your takeaway on this, make sure that your HR teams understand the importance of getting that I-9 field fully completed, sections 1 and 2, conduct an audit of your existing I-9 forms, recommended to do that under privilege with your attorney to identify and correct any of these technical errors that can be cured now before you are subject to an official audit. And make sure that all of the employees that are responsible for onboarding know when the I-9 must be completed and the acceptable documentations and verifications procedures that are required. And you also want to make sure that your records are in good shape so that you're able to promptly provide those whenever you have, should you be subject to an audit. And then finally, just want to mention that the Department of Labor has proposed a new rule on joint employment in April, and that is the goal for this new rule is to define joint employment for both the Fair Labor Standards Act, the Federal Wage and Hour Law, and the Family Medical Leave Act, FMLA, as well as Migrant and Seasonal Agriculture Worker Protection Act. And so the information is there on the slide about how they're going to define horizontal and vertical joint employment. And so you want to be thinking about that, particularly if you are closely affiliated with another company in the with regard to an employee's work. And there could be additional liability if you are exerting certain types of control in monitoring or supervising and hiring or firing employees. So any questions on that, we're happy to answer those. But again, just a proposed rule, not in effect yet. All right, well, I think we are right at time. If anyone has any additional questions, feel free to put them in the chat. We will be providing the presentation as well as the recording to participants and anyone that wasn't able to join today as well.
Julie, it looks like we got a few last minute questions after I'd wrapped up on the Virginia Wage Transparency Act that I'm happy to answer now. But combining two questions goes back to the issue of asking someone what the base salary requirements are and whether or not they should remove the question on their application of listing the salary requirements for the position. Again, it's not prohibited by the law to ask someone what their salary requirements are, but you need to be extremely careful if you do that. It may not be the safest thing to do because of the way the law is structured as far as asking someone what their past salary was. Again, the goal of the law and the reason why they're requiring you to provide the compensation bands is so that people understand what the expectations are, so that to the person who asks, if a job is paying a maximum of 90 and a candidate is coming in requiring 150, what do we do? Well, you're going to have had a salary band that sets the expectation, so the person coming in knows that the cap is 90 and they're still applying for that job anyways. Again, it's not going to be a strict violation of the law to ask them, what are your salary expectations, but just being very careful on how you're phrasing that and to avoid front-facing things that could raise concerns of being fishing for past salary and past compensation. I would generally err on the side of caution and have those conversations a little further down the line once you've narrowed your applicant pool, because people are going to know up front now with these salary bands what the compensation expectation should be and then align themselves within there. And additionally, we've been seeing in jurisdictions that have these compensation bands, the question of your salary requirements or expectations tend to be a little less effective now because every single person is just going to list the top, whether or not that actually meets what their where they would stand within sort of the seniority of the experience range, education range, within that range if you're posting a range. So you may see that there's not really it's not really as effective as it used to be to ask that question anyways.
Yeah, and I think certainly you could, in the interview process, just reiterate, this is our range for this position. The goal is hopefully to get folks to self-select, right? Looks like there's a question. Do we need to remove the question from the employment application? Please list your salary requirements for this position.
Yeah, that was one of the ones that I'd combined with the last one. Legally, as far as the laws stated, no. Is it going to be an effective tool to bring in information that you're going to use? Potentially not. And is there a potential risk as this law gets fleshed out a little bit that someone says that this was a fishing expedition into what their prior compensation was? Potentially. So if you're not going to be getting my rule of thumb, if you're not going to be getting useful information from something, putting it out there, especially on a public facing forum where these plaintiffs firms that do these fishing expeditions and look for potential lawsuits and potential things to pursue, if you're not going to be getting useful information because someone's going to just put the maximum of the range or something within the range, then I don't know that it is a great idea to keep it on there, even though it's not a legal requirement to remove it.
Great. Well, thanks everyone. This is a great meeting, and we hope that you were able to get a good update on changes in employment and labor law at the state and federal level. Happy to answer any questions that you have or work with you on adjusting your existing policies and practices for compliance. Thanks so much. Have a great day.
Thanks, everyone.